Hi, I'm Stuart Hill. I'm just coming up for my 73rd birthday, and some people think I should be I should have something better to do than doing what I'm doing. But I need something to keep me on my toes. I'm lucky enough to live in Shetland, the northernmost and remotest part of the British Isles. We're stuck out here in the Atlantic at 60 degrees north. That would be considered subarctic in most countries. Our nearest railway station is Bergen in Norway, so it tells you how remote we are. I'm going to tell you about the latest twist in my efforts to get Scotland and the UK to show how they derive their authority in Shetland. I don't believe it really exists, but is simply a long-held and well-nurtured presumption that's become so strong that nobody questions it. If it is anything more than a presumption, it must be capable of being defended in court, and that's what I set out to do. Now, most people don't even know where Shetland is, but those that do almost universally think that Shetland is part of Scotland. That's the official line, and it's been promoted for hundreds of years. Since 2002, I've been researching Shetland's history and questioning that universal presumption. Of course, Scotland and the UK would like us to believe the myth, but the more I looked into it, the more I realised that not only was it not true, but that it could never have legitimately happened at all. So very briefly, in 1469, when Shetland was part of the Danish kingdom, the King of Denmark pawned his lands in Shetland to King James III of Scotland when he couldn't come up with the money for a dowry for his daughter's wedding to James. All James got was the king's lands, about 10% of Shetland, held in trust until the Danes came up with the money to redeem them. That's all the Crown has ever had, 10% of Shetland held in trust, not given, not owned, and certainly not the whole of the islands. For that and other fundamental reasons, it's never been possible to incorporate Shetland into the realm, although there have been a number of botched attempts. Anyway, James and succeeding monarchs proceeded to act as if they owned not only the 10%, which they didn't, but the whole of Shetland. They farmed the islands out with invalid feudal charters to various needy and rapacious courtiers, as Balfour put it, and then took them back when those courtiers fell out of favour. At no point did the Crown get a legitimate title which would enable Shetland to be incorporated into the realm. It's a long and convoluted story, the details of which have been well buried, but it's explained in detail in my book Stolen Isles, which you can find at stolenisles.com. You'll find the link below. If Shetland is not part of Scotland, it has profound implications for the UK. Excluding North Sea oil, the UK Treasury benefits by about £76 million per year net from the Shetland economy. These are official figures. In other words, after we've paid out all our direct and indirect taxes and got back all the grants and subsidies, there's £76 million every year left in the UK Treasury to help pay for things like illegal wars, HS2, MPs' expenses and so on. There's around 10,000 households in Shetland, and I'm sure that each one would rather have 7,600 in their hand than pay it out for those expenses down south. Oil production from Shetland's waters has been in excess of £50 billion per year in the past few years, giving a tax revenue of £10 billion per year, although the price has recently dropped. That doesn't take into account revenue from the considerable gas reserves. The UK does rather nicely out of Shetland. From a wider perspective, if Shetland is not part of Scotland, whatever it was that joined the EEC, later the EU, could not have included Shetland. So it puts into question the entire UK membership of the EU. It's easy to see why the UK government would want to bury this issue if they have no legitimate title. On the other hand, if there is a legitimate claim, it should be easy for them to point to a document or a date when it happened. So after making polite inquiries from those who should know, that's everybody from the Queen downwards, and getting no straight answers, I started to challenge the UK's authority in the courts. I was surprised to find, first of all, that the question had never been tested in the courts, and that all those people who confidently asserted authority on behalf of on behalf of Scotland or the UK, were acting merely on a long-held and well-nurtured presumption, but a presumption nevertheless. Quite unintentionally, my efforts took me into every level of court in the Scottish system, both civil and, if you like, criminal, and involved being held in police cells and even imprisoned when I was simply asking the courts to prove their jurisdiction. I found that judges would go to any lengths to avoid facing the question, is Shetland part of Scotland? When it became clear that judges at every level in the Scottish system were willing to ignore the legislation and break their own rules and the law in their attempts to avoid facing this simple question, I began to wonder, who's the criminal here, me or the man on the bench? But I knew with certainty that I was on the right track. Just before Christmas 2014 came the opportunity to take my cause to the highest court in the land, the Supreme Court in London. Opponents to a giant wind farm development in Shetland had made an appeal to the Supreme Court. Although the case was nothing to do with me directly, if Shetland is not part of Scotland, the Supreme Court can have no jurisdiction here, and they would need to know that. Nobody else was going to tell them, so it was up to me. When I started to inquire from the court how I should get involved in the case, almost immediately I could feel resistance. There's a detailed account on my website at www.sovereignshetland.com. It's worth reading the full account to see how shifty they were. You can see the links below. It also became clear that if I followed the official route, there was no chance of being allowed in. Neither the court nor the parties wanted my interference. However, jurisdiction either exists or it doesn't, and it was not necessary for me to be part of the case in order to tell them. So instead of following the court protocol, I sent a comprehensive notice of no jurisdiction to the court and was assured, well, eventually, that it had been placed on the case file. As you read the account on the website, you can see why I could detect a certain deviousness in their correspondence. Anyway, generous support from my members and well-wishers enabled me to fly down for the hearing, which evidently caused some consternation, because the registrar let it slip that before coming down to explain why I couldn't sit in the body of the court, she had informed the judges of my presence in the court. Why would she do that if it was not a matter of concern for them? When we spoke, I discovered that my notice was not in the case file at all, but only in the court record that the judges don't see. If I'd not attended the hearing, the judges could quite legitimately have claimed they knew nothing about it, but I managed to get a very reluctant assurance that they'd see it before the hearing, which was later confirmed in writing. Had I not been there, I'm sure it would have been quietly buried in the wrong file, and they could continue with business as usual with no qualms, which is evidently what they decided to do. Having decided on a course of action, there was no plan B. Nobody expected me to actually turn up. Ultimately, the court can't decide its own jurisdiction. If challenged, it must hear proof from the party bringing the case. If it proceeds without proof, it is, in the words of one of the judges I cited in my notice, a court without jurisdiction purporting to exercise it. It means there are no judges in the court. The men on the bench would have no more authority than a man in the street, and any action they might take is null and void, as if it had never happened. By proceeding without jurisdiction, they would lay themselves open to personal liability and charges of contempt of court, fraud, and other criminal activity. This was all laid out in my notice, and it's not my opinion merely, but solid case law. Knowing there was a challenge to the court's jurisdiction, the proper course for the judges to follow, and the one that gave them protection, was to have a short pre-hearing before the main hearing, where they asked the party bringing the case to show how the court has jurisdiction. It should be routine and should not be difficult for them to be shown proof, unless of course it doesn't exist and everybody knows it. They must have known the risks they were taking, but the hearing started and continued with not a whisper of a lack of jurisdiction. A few days after the hearing, I sent a notice of void proceedings to the registrar and to each of the 5 judges, including, for good measure, a copy of the original notice of no jurisdiction in case the judges didn't actually get a copy the first time round. The main points in the notice of void proceedings are that there's no proof that Shetland is part of Scotland, that no court has heard any evidence that Shetland is part of Scotland, that the appeal proceedings are void because of a lack of jurisdiction, that the judges were purporting to exercise jurisdiction they didn't have, that by proceeding in the knowledge of a lack of jurisdiction they were reckless, in contempt of court, and acted fraudulently, and that all proceedings prior to the appeal hearing were void, and the original permission from the Scottish Government is also void. I've now got confirmation that my package was received by the court on the 2nd of January and that they passed on the relevant parts to each of the men acting as judges. So, having been notified, neither the court officials nor the judges can deny knowledge of a lack of jurisdiction and the consequent void proceedings. It means that not only were those proceedings void, but all prior proceedings in the case and the original permission from the Scottish Government were also void. What they'll do now is anybody's guess. I'm just a lone pensioner, and they are the all-powerful highest court in the land. But I'm right and they're wrong. The Scottish courts have shown a clear disregard for the rule of law. It remains to be seen whether the Supreme Court is any better. I certainly hope so, but I'm not holding my breath. All the indications are that it's well known in high places that there is no legitimate authority in Shetland. The whole structure can only be maintained by force in the final event, and as long as people don't ask questions. Another interesting aspect to all of this is that although I gave this information to all the major newspapers, it's been completely ignored. I would have expected at least some interest in a story concerning potential corrupt behaviour at the highest court in the land. I'm often asked, why am I, an Englishman, interfering in what should be the business of Shetlanders? My research showed me that the people of Shetland were once sovereign in their own right. They owned their land outright, they elected their king, they made their own laws, and they had their own parliament. There can't be a more complete definition of sovereignty than that. Incoming Scottish dignitaries with a false authority granted by monarchs that had no right to give it gradually usurped the rights of the people until they were reduced to little more than serfs. It became ingrained in the Shetland psyche that you don't argue with authority figures. In the recent past, it meant that you'd be turned out of your home and lose your livelihood if you had any argument with the laird or the minister. Shetland then and now was seen as a cash cow, and the inhabitants could and can be relied upon not to question their position, not to question apparent authority. However, nothing was ever done to legitimately remove those original rights. It was done and continues to be done by presumption, and that presumption will continue as long as it's not challenged. I would like to see Shetlanders realise their true potential of being sovereign in their own right, and that need not be done by violent protest. Shetlanders simply have to make their own presumption that they are sovereign, that their sovereignty has never been taken away, only buried and forgotten. In truth, Shetland is symptomatic of a much wider problem where the imperial ambitions of a few have enabled them to gain such power that they think they have a right to impose their rule over the rest for their own advantage. My aim in Shetland is to find a way for people, when they really get fed up with our existing system and realise that it can't be fixed, when they realise that they don't want to be part of a system where a small but powerful and totally corrupt group has got a stranglehold on power and won't willingly let it go. and where over 90% of the wealth is in the hands of 2% of the population, to be able to simply turn their backs and join a society with rules they wish to live by, where power really is in the hands of the people, where democracy really does mean government of the people, by the people and for the people, where fair money, fair justice and an education system designed to develop the highest human potential are all the norm. It's not a lot to ask, is it? And Shetland is where it could happen.